You're listening to In the Balance, an Iowa Judicial Branch podcast. Welcome back. This is a special episode for us as it marks our one-year anniversary of In the Balance. I want to say thank you to everyone who has taken the time to listen over the past year. In honor of Constitution Day next month, we are spending this episode sitting down with Justice Brent Appel of the Iowa Supreme Court to talk about the roles the Iowa and United States Constitution play in the appellate court system. Constitution Day celebrates the ratification of the United States Constitution on September 17, 1787. Congress established this day as a federal observance in 2004, but Iowa has been celebrating in one way or another since 1911. While this holiday observes and celebrates the federal constitution, it's also a time to reflect on Iowa's own constitution, which was adopted on March 3, 1857. Iowa's court system began, though, on June 12, 1838, when Congress formed the territorial government in Iowa. The act established a Supreme Court, probate courts, district courts, and justices of the peace. When Iowa joined the Union in 1846, the Iowa State Constitution was enacted. The Constitution of 1857 is what endures to this day. Iowa honors both the federal and state constitution during Constitution Day because both play a role in our court system. In the appellate court system of Iowa, comprised of the Iowa Supreme Court and Iowa Court of Appeals, the judges and justices look to both the state and federal constitutions to aid in their decision-making. The United States Constitution is applicable to all states on a federal level, yet each state's constitution affords its citizens different rights and protections. The Iowa Supreme Court hears all accepted cases of constitutional questions where parties are making arguments using either the state or federal constitutions, or in some instances both, as well as past case decisions regarding constitutional rights. To get a clearer view of what makes Iowa's constitution unique, I spoke with Justice Brent Appel, the senior-most justice of the Iowa Supreme Court. Justice Appel, thank you for joining us today. Before we dive into our topic, tell us a bit about your path to the Iowa Supreme Court.
Well, first of all, thank you for having me today. It's a delight to talk about constitutions on Constitution Day. As for my own career, after law school, I clerked for the D.C. Circuit in Washington, D.C., and that certainly stimulated an interest in the judicial branch. My first legal job full-time after my clerkship was in the Iowa Attorney General's office, where I had the privilege of arguing 4 cases before the United States Supreme Court. After my stint in the Attorney General's office, I entered private practice in central Iowa for a couple decades, mostly a litigation practice, commercial cases, employment law matters, and I represented the state as private counsel in important tobacco litigation. I arrived at the court in 2006, on my third attempt, I might add, to secure a judicial position. And I'm in my 15th year of service, which will be my last, as I face mandatory retirement in July of next year.
And as you mentioned before, today we're talking about Constitution Day, which is coming up on September 17th. And I think a good place for us to start off would be, why do we have a state constitution in addition to the federal constitution?
Very interesting question. And a little historical background might be of help. The first written constitutions were state constitutions. Several were adopted in 1776, more than 10 years before the federal Constitution. New Hampshire, South Carolina, Virginia, New Jersey, and then a number afterwards. So at the time of the Federal Constitutional Convention, there were 11 state constitutions already in place. And the framers of the federal Constitution drew heavily on what Jefferson referred to as the 150 years of Republican experience under the state constitutions. There was the state constitutions that were hailed as establishing written constitutions first. And Ben Franklin published, for example, a compendium of state constitutions in Paris. And it was widely read among the intellectual class, at least. So the state constitutions predated the federal constitution, and today we have parallel constitutional systems, the federal constitutional system and the state constitutional system.
In Iowa, then, what are some aspects of our Constitution that differ from the United States Constitution?
Okay, well, there are provisions that are quite similar and provisions that are quite different. And I'll highlight just a few of them. Let's begin with the Iowa Bill of Rights. The Bill of Rights in the Iowa Constitution is in Article 1, the very first article. It has a number of differences from the federal Bill of Rights. For example, Article 1, Section 1 is derived from the Virginia Declaration of Rights. It declares in part, all men, and now women, of course, are created free and equal and have certain inalienable rights, et cetera, et cetera. Listeners will identify that with the Declaration of Independence. But the Declaration of Independence, just like the United States Constitution, was based on a prior state document, the Virginia Declaration of Rights, George Mason's. That has a natural law tradition behind it, and is notably absent from the United States Constitution. Our right to counsel provision in the Iowa Constitution, Article 1, Section 10, is different. Not only does it provide for counsel in criminal prosecutions, but also in cases involving life or liberty of an accused. An additional phrase is in our right to counsel provision, and there is some history behind that. The Iowa Constitutional Convention in 1857 was dominated by Republicans who were very much anti-Fugitive Slave Act, and they were seeking to inject rights for fugitive slaves, contrary, by the way, to federal law and contrary to the rulings of the United States Supreme Court. But anyway, so there's a difference. We do not have a right against self-incrimination in the Iowa Constitution. Well, of course, the federal Constitution has the Fifth Amendment. We have, however, interpreted the Due Process Clause of the Iowa Constitution to include a right against self-incrimination. Iowa does not have an Equal Protection Clause. The federal government, the federal Constitution was amended with 3 Reconstruction amendments. We did not have those amendments. Arguably didn't need them because we never had slavery. And we did have Article 1, Section 1, which is an equality provision. But what Iowa does have is Article 1, Section 6, that's kind of similar, a uniformity provision, and a provision related to privileges and immunities. And so the language is different, and it at least has some overlapping concepts. Iowa also does not have an Equal Protection Clause as the federal Constitution does in the 14th Amendment. Instead, we have a uniformity provision in Article 1, Section 6, stating all laws of a general nature shall be uniform in operation. And we have a privileges and immunities provision, basically saying that citizens are not granted, that privileges and immunities cannot be granted specially, but need to be given to all citizens on the same terms. So there's that linguistic difference. We have different language in our jury trial provisions. Article 1, Section 9 says the right to jury trial shall remain inviolate, while the federal Constitution has a somewhat different formulation. Amendment 7, jury trial should be preserved, etc. However, some of our constitutional provisions are very similar. Our provision related to search and seizure, Article 1, Section 8, is very similar to the, and virtually identical, with a few punctuation differences to the federal model. Now, the mere fact that the language is the same does not mean that the state Supreme Courts cannot construe their provisions differently, however, than the federal constitutional provision by the United States Supreme Court. Now let's turn to the differences in the legislative branch. Keep in mind the Iowa Constitution, the first Iowa Constitution was enacted in 1846, and then the second in 1857. Both, however, are products of the Jacksonian era. Remember, Jackson and his party was opposed to the Bank of the United States. They saw government and private interests as being kind of in bed with one another. And they were concerned that the legislative branch should be limited in its powers with respect to private enterprise. So there's restrictions on the ability of the legislature to regulate corporations. For example, state government cannot be a stockholder. There's no special corporate charters allowed in our state constitution. There are provisions also on state debt in the Constitution that aren't in the federal Constitution. Article 7 of the Iowa Constitution basically requires a balanced budget and so forth. We don't have that in the federal. There's an item veto provision, which allows the governor to item veto appropriations. That is not in the federal Constitution, of course. There's provisions in the Iowa Constitution related to the legislative process. All acts are to have one subject embraced in the title of the bill. It's kind of an what we call anti-log rolling provision. The founders didn't want grand political compromise on unrelated topics. So there's a number of differences in the Iowa Constitution as it relates to the legislative process that are not present in the federal model. Turning to the executive, there's some differences. Of course, the federal executive still today is elected through the Electoral College. It's kind of a controversial issue, but in practicality, the Electoral College's role has been diminished. But the Constitution provides for election by the Electoral College, at least. And Iowa does not have that. We have direct election of the governor. Item veto power has already been mentioned, but governors really like that in state governments. It gives them an added power with respect to the legislature. Also in Iowa, executive functions are distributed among a number of office holders. We have a Secretary of State, a state auditor, a treasurer of state, and we have an attorney general. Interestingly enough, the attorney general is under the judicial branch in our Iowa Constitution. But my point is the Iowa founders wanted to scatter executive power among multiple office holders. We don't see that feature in the federal Constitution. Lastly, I'll just talk briefly about the judicial branch. There's some differences there. The federal courts are what we call, quote, Article 3 courts. That's what lawyers kind of say. This is an Article 3 court. And in Article 3 of the United States Constitution, the judicial power is limited to cases or controversies. We do not have a case or controversy limitation in the Iowa Constitution. We do have kind of some similar doctrine. We don't like to just go off in the Iowa Constitution, under the Iowa Constitution, with advisory opinions and so forth. But in Iowa, the approach to who can bring an action is prudential in nature, while under the federal system it may be constitutional. The manner in selection of judges is different. The president nominates, of course, and we all are familiar with the confirmation process in the Senate. Here in Iowa, you self-nominate. You say, hey, when there's a vacancy, you apply, and there's a judicial qualification commission consisting of lawyers and citizens, and they meet, send finalists on to the governor, who selects the judge from the finalists. And then judges stand for so-called retention elections. And that simply is an election. In case of Supreme Court, it's every 8 years, and the question is, shall Brent Appel be retained as a justice? And the voters have an opportunity to say yes or no. If the answer is no, your term comes to an end. And if the answer is yes, you have another 8-year term. So those manner of selection of judges is certainly different in the Iowa system than the federal system.
And then how does the Iowa Constitution compare to other state constitutions?
Well, that's a very interesting question, and it has similarities and differences. For example, a number of states use Declaration of Rights language that's very similar to Article 1, Section 1 that I spoke of: Virginia, Massachusetts, New Jersey, Pennsylvania, Vermont, etc. And when the state constitutions were developed, the conventions always wanted copies of what other states did. And so they cut and paste. California, for example, the California Constitution has a lot of provisions very similar to the Iowa Constitution, because California Constitutional Convention explicitly relied on Iowa. There are 50 state constitutions, and they all have their various differences, but there's a rich body of case law in these 50 states on a wide range of issues. A lot of diversity.
With that diversity, as well as using the federal constitution, what are the benefits of having, as you said, 50 state constitutions and a federal constitution? And then what are some of the frustrations that arises from that as well?
Okay, let's start with what scholars have seen as the benefits, and I'm going to refer the readers to a fine volume. Jeffrey Sutton, a judge in the federal system, a federal appellate judge, recently published a book called 51 Imperfect Solutions, and it describes at some depth the role that state courts have had in the development of constitutional law, and finds it as being very helpful. The general thrust of Sutton's argument is that diversity in the development of constitutional law leads to vibrant legal development. There are provisions of the Constitution that we lawyers characterize as open-textured, meaning it's not obvious when you just read the words what they mean. I mean, what does due process of law mean? It's not clear by just reading the words. Sutton notes that the federalist system, where state courts are allowed to develop their own constitutional traditions, provides for tremendous legal experience and diversity. Sutton rejects an approach where the United States Supreme Court is the sole arbiter of state constitutional issues. He wants to see this fervent legal development. Historically, Sutton has an excellent point. A number of the major Supreme Court cases that are hailed as seminal had state court precedents that were kind of driving the law. And I'll just cite a couple. Loving versus Virginia. Some of you may have seen the movie dealing with interracial marriage. Major Supreme Court case ultimately struck down state anti-marriage statute across races. It was preceded by a California Supreme Court case, the Perez case. Virtually all of them. Powell versus Alabama, right to counsel. A lot of state court precedent before Powell versus Alabama. You read the case, and there's the United States Supreme Court citing all the state court precedent. Batson is a case that the United States Supreme Court came that basically says prosecutors cannot intentionally strike African American jurors from jury selection process. And the jury selection process that was preceded by state court precedent. We could go on and on and on, but the notion is that the state court precedent ferments and provides the diversity that is the very point of the federal system. That's the plus side. Critics have raised a number of points. First is lack of uniformity. Why should the rights in my hometown of Dubuque be any different than across the Mississippi River in East Dubuque? Second, it's sometimes said that it's more efficient if we just have one set of rules. If we have just the one set of rules and it's the federal rules, there's a huge body of case law, federal case law out there, and appellate courts and lawyers work on hundreds of cases a year to have access to that federal case law and assume that applies under the state constitution is more efficient. It's less work. Less time is spent thinking about law, more time spent on application. Sometimes it's said that law enforcement will be confused. They won't know whether to follow one set of rules the other or another. And lastly, there's sometimes a question of competence. Some have questioned the competence of state court judges compared to federal court judges. The argument is that the federal positions pay more, are more prestigious, get a better applicant pool, and have more staff support. And on the latter point, there's absolutely no question. The staff resources that are available to state Supreme Court justices is dwarfed by what, of course, the United States Supreme Court has. The contrary position is, well, if you look at key Supreme Court decisions, you might not have great confidence in them. Dred Scott, of course, the decisions that said African Americans had no rights that the white man was bound to recognize, of course, a Supreme Court decision. The Reconstruction cases after the Civil War ultimately were thought by most legal scholars to be very unsatisfactory. Korematsu versus the United States, that's the Japanese internment case, is thought to be a low point. So if the quality of the federal judiciary is supposed to be so high, some might say, well, the results of some of these cases suggest that it's not invariably the case. I think as a general proposition, you can say those that embrace state constitutional law have an appreciation for the evolutionary and dynamic qualities of law, while those that are more reluctant to embrace state constitutional law are more oriented toward the values of stability in the law.
You mentioned earlier when we were discussing the Bill of Rights language, how it once stated men and now is meant to be interpreted as men and women. And that comes from both our state constitution and the federal constitution being amended over the years. So what is the process for adding amendments to both of these constitutions? And what effect does that then have on court decisions?
Well, the Iowa constitutional provision is much different than the federal constitutional provision. Article 10 of the Iowa Constitution provides two routes for amendment. The first is through the General Assembly. And under this route, two separate General Assemblies must pass the identical amendment, which is then presented to the voters for majority approval. Note, it has to be an identical amendment. There can't be word variation. If there's word variation, you need to get another General Assembly to approve it. You need two approving the same amendment. The reason for that is that this constitutional provision provides for an intervening election, and therefore the two separate General Assemblies will have a somewhat different character. The second route is through a constitutional convention, and the Iowa Constitution provides that every 10 years, the question of whether to hold a constitutional convention is on the ballot. And the voters could say yes, in which case there'd be a constitutional convention. The voters, however, have routinely said no, and we haven't had a reconvening of the Constitutional Convention in recent years. Now, let's go through a number of recent amendments just to give you a flavor. The Iowa Constitution has been amended to include women in the phrase, all men are created equal. It now reads, all men and women are created equal. The phrase, no idiots language that was in a previous suffrage provision has been eliminated. And most recently, there's been an amendment to create a natural resources and outdoor recreational trust in 2010. All right, let's look at the federal Constitution. That's in Article 5 of the Constitution. Congress may propose amendments by 2/3 majority of both houses, and then the amendment must be ratified by 3/4 of the states. That's the first route. The second route is by a constitutional convention proposed by 2/3 of the states and ratified by 3/4 of the states. There have been 27 amendments. The most recent amendments relate to presidential succession, the right to vote for those who are 18, and compensation of members of Congress. Now, generally speaking, the amendment process to the United States Constitution is more difficult than the Iowa Constitution. It has to be ratified by 3/4 of the states, even if it comes from a convention or if it is proposed by Congress. 3/4 of the states must ratify. That's a very high bar. Some scholars have suggested that one of the reasons it was so high was to make sure that it gives the southern states confidence that there wouldn't be constitutional amendments related to slavery. And I think the bottom line is that the Iowa Constitution can be amended somewhat more easily than the federal Constitution.
And as a member of the Supreme Court, do you deal with cases pertaining only to the Iowa Constitution or to the U.S. Constitution as well?
Well, we deal with both of them. And let me march through some of the scenarios. First, a party might solely raise the United States constitutional provision. In those cases, we decide the constitutional provision, but we are bound by decisions of the United States Supreme Court. So we read United States Supreme Court cases and basically try and predict what the United States Supreme Court would do. Some parties raise solely the Iowa Constitution, and in those cases, we look to the Iowa constitutional provision and decide that. The difference here is that our decisions are binding. The decisions of the Iowa Supreme Court are binding, and not the United States Supreme Court decision. So we are free to determine what we think is the best constitutional approach under the Iowa Constitution. In some cases, the parties raise both the United States Constitution and the Iowa Constitution. And there we have the ability, at least, to consider either provision. If the United States Constitution is dispositive on the legal issue, we might not reach the state constitutional provision. But we have authority to decide both cases under the United States Constitution and the state constitution. The key difference is the United States Supreme Court decisions are authoritative under the U.S. Constitution, while it's the decisions of the Iowa Supreme Court that are authoritative under the state constitution.
So for an example of a case that would be of constitutional question, we've had quite a few cases come before the Supreme Court where legislation is signed into law, and then that is challenged on constitutional grounds. How do you prepare for that type of case, and what are the ramifications in your decision-making process for that law?
Well, let's talk a little bit about process. The first thing I think most of my colleagues do, and certainly the first thing I do, is read the briefs. The parties have the opportunity to present to us case law and any history that seems germane and can point us to any part of the record. Some constitutional cases are pure issues of law, and so we can focus solely on cases. Others involve questions of fact. And when that's true, we will have to examine the record that was developed in the district court in some detail. We look at the cases that the parties have cited with a critical eye. We look to see if they've been distinguished. We look to see if they're actually on point. We look to try and determine what the underlying principles are in the case law. We spend a number of hours, obviously countless hours really, trying to twist and turn and examine. One of the things we have to do in constitutional cases in particular is we ask all the what ifs. What if this, what if that? Because a constitutional principle is going to be one that could have significant impact on a wide variety of cases. One of the things I'll also share while I'm at it is the role of a court is not solely to decide cases, although that's a really important role, obviously, but the scope of the legal principle applied to decide the case is very important because you don't want to have unintended consequences, for example. That's generally how we approach it. In a constitutional case, we almost certainly will have oral arguments, and they can be helpful as well.
And lastly, what do you hope the citizens of Iowa take away from Constitution Day celebrations?
Well, written constitutions are wonderful things. The whole purpose of a written constitution is to establish processes and rules of law for the operation of government, both the affirmative operation of the legislature and the executive, and the negative of courts and enforcing Bill of Rights and making sure that transient majorities don't overreach. But it's a written game plan. And prior to these constitutions, that wasn't the case, and that kind of meant whoever had power could do whatever the people in power wanted. We have a system of limited government, and that was thought to be revolutionary in 1700s, and it needs to be honored and recognized as extraordinarily valuable today.
Thank you so much, Justice Appel. You've been listening to In the Balance, an Iowa Judicial Branch podcast hosted and produced by me, Marissa Gaal. If you would like more information about Iowa's courts, you can visit www.iowacourts.gov. You can also follow the Iowa Judicial Branch on Twitter and YouTube at Iowa Courts. This episode of In the Balance is now adjourned. Until next time.